It's an absolutely true story. So I am going to talk about some new ESA leaves. I'm also going to talk about random drug and alcohol testing, specifically a Supreme Court of Canada decision that came out just under 2 hours ago. And we'll see if in the next few minutes I can come up with a segue between the two of those. So the ESA, the Employment Standards Act, currently contains 7 discrete unpaid leaves of absence. Some of those are ones that we all would have seen in practice: parental leave, maternity leave, personal emergency leave. Some of them, maybe not as often: organ donor leave, reservist leave, declared emergency leave. There are currently 3 more leaves that are set to come on the books. They're currently in Bill 21 in the legislature. They've passed second reading, and we're just waiting to see where they go. And they are family caregiver leave, critically ill child care leave, and the ultra-specific crime-related child death and disappearance leave. So what we'll do is, even though they're not technically law yet, we're quickly going to go over what's included in those leaves so that you're prepared in the likely event that they become law. So family caregiver leave has no minimum requirement for application, so employees will be able to take it once they start, and it provides for 8 weeks of unpaid leave where a defined list of family members experiences a serious medical condition. Serious medical condition is not defined within the bill, and so we don't quite know what's going to be required. You'll need to go to a doctor, and they'll need to present a certificate that the person suffers from a serious mental or medical condition, but we don't know exactly what that means. What we do know is that the government really has intended this leave to allow children, older children, to take care of aging parents. That really is the gist of it. And so the government, when asked to give examples, actually did say broken hip would be considered a serious medical condition, but they really didn't get any more specific than that. So we will have to see if anything changes in committee or what actually arises. One potential problem that has arisen is that the leave must be taken in whole week blocks. And so even if an incident happens with a family member and you need to take off 2-3 days, even if the employee comes back to work, you'll be required to pay them for the work that's being done under the Act, but you will still be required to deduct a full week off of their leave entitlement. And the provincial government has approached the federal government and asked them to potentially look at creating a new EI entitlement to fit in with this leave. The last thing is, like other leaves under the Act, there's a requirement for the employee to give written notice where they do intend to take this leave. However, we expect that, as with other leaves under the Act, if the employee doesn't give the written notice, it doesn't disentitle them from taking the leave. They're still able to. All it will allow employers to do is potentially discipline the employee for not providing the notice if that's provided for in a policy. The second one, critically ill child care leave, can only be taken once an employee has been employed for 6 consecutive months, and it allows for 37 weeks of unpaid leave where they can present a medical certificate from a qualified health practitioner that states that a child is critically ill and requires care. Again, critically ill is not defined in the Act. There is already a fairly new EI entitlement covering similar situations, and so the legislation actually has in it right now, it says essentially what is critically ill child, see employment insurance regulations. So there may be some debate at first about what falls within that category, and so we'll wait to see how that emerges. As well, this leave also must be taken in full weeks. And finally, the employer and employee must work on a plan that will show when the employee takes the leave and when they'll come back. But as with notice, we expect that if an employee doesn't complete the plan, that won't disentitle them from the leave. And the last one is the crime-related death or disappearance leave. Again, the employee will have had to have been at work for 6 months or more in order to be entitled to it. And what this allows is for 52 weeks, a full year of unpaid leave, in the event that a child, which includes a stepchild or a foster child, disappears, and it is probable that the child disappeared as a result of crime when we consider the circumstances. Now, what does that mean? We don't quite know, because none of that is defined. It's likely that the employer will be the one that is ultimately to decide whether in the circumstances it likely was as a result of crime. The employer does have the ability to ask for evidence that's reasonable in the circumstances to determine whether the employee is entitled, but certainly there is a gray area in terms of how that will be adjudicated and whether or not employer decisions to allow employees to take this leave will be reasonable. The other interesting thing is if it later turns out that the child has unfortunately died after the disappearance, the employee may have another 52 weeks, so in other words, a full 104 weeks of statutorily protected unpaid leave. And this fits in with an existing federal income support grant that started in January 1st, 2013, that does provide compensation for up to 35 weeks for parents that have murdered or missing children and whose death or disappearance was the result of a suspected crime. So again, these aren't quite law yet, but it is important to consider them because as these leave provisions continue to accumulate, as the pile grows bigger, we need to be aware of what our obligations as employers are to ensure that we are complying with the rules and regulations under the Employment Standards Act and making sure employees get their entitlements or obligations under collective agreements, because it is increasingly easy as employers to find ourselves running afoul of the law in cases like that. Speaking of running afoul of the law, Irving Pulp and Paper.
Now, I'm going to have to stop.
Okay, yeah.
This is going to be fascinating, but
All right.
we're going to move to the next
Done.
topic.
Thanks.